I mean, the community trusts us, the community trusts what we do. I don't see why you guys can't trust what we're doing as well. And I know you guys are gonna argue that we do trust you, but in conversation, that's not exactly what it feels. And I don't wanna speak for the staff, but I can tell you that I'm pretty sure they're feeling pretty untrusted by this discussion as well.
I, for one, would like to hear from our attorney, our city attorney, Jack Lovager, who's been sitting here being very, taking it all in, and obviously he's here for informed reason that we follow what is legal and binding.
And I'm not gonna talk as much about the display issue because that's not really the heart of it. What I think exposes the city and the library to problems.
Can you
Yeah.
I usually don't need a microphone, but
Yeah.
you ask for it, you're gonna get it. Well, the display issue may or may not be a different issue, but primarily why I'm here tonight, and there's a couple things I think that the board may want to keep in mind going forward in terms of its agenda development. And so we don't end up in a situation where half the people in the room believe that a certain item is going to be acted upon when it is not. And certain people are likely disappointed that it's not going to be acted upon. And unintentionally, had that matter been acted upon either favorably or unfavorably, it could have opened up this board to an Open Meetings Act violation, because the Open Meetings Act requires you to publish a certain number of hours before the meeting the subject matter of what you're going to take action on. And the proposed amendment to the acquisition policy was never posted on the website. It was never actually, there's never been a motion to add it to the agenda. It's certainly appropriate and allowable for you to talk about that subject. It would have been, I would have advised you not to take action on it tonight, and I think Mr. Allen was correct to say this is not something we should be acting upon tonight. So I think some thought should be given to, and at the city level, the city council has rules of procedure for how they conduct their business. And one of those rules provides, and there's a distinction, members of the public are allowed to ask for items to be placed on the city council agenda that are considered non-administrative in nature. In other words, members of the general public are not allowed to come in and say, well, I want to micromanage the city manager. It's the job of the city council to supervise the city manager. But on matters that are not administrative, they can propose that matters be placed on the agenda for either discussion, and if they do it by, I believe you have to have them in by noon on Wednesday before the Monday meeting, it will be added to the agenda. Members of the council are given a little more leeway and are allowed to bring up items of administrative matters because they are the supervisors of the manager. And I'm not saying you have to have some cumbersome process. And one of the things that's remarkable to me, I've been the city attorney for almost 7 years, but I've lived in this community now going on 34 years. There's never been a controversy at the Hillsdale Library in 34 years. People don't come to the library meetings. Maybe they should. And I've been involved in, and I'll tell you, that's very different than the Hillsdale City Council, where Penny can tell you that it's a circus a lot of times. And it's a circus a lot of times because a lot of people don't really know what's going on, don't pay attention, don't educate themselves about what's going on, and they come in with an opinion and they want to be heard. And it's I guess to be commended that the library has run itself in a pretty non-controversial manner, perhaps because it's kept itself pretty neutral, as its mission statement says. Now, having said that, it might be worth considering having some, so going forward, having some kind of a procedure to say, if a member of the board wants a policy to be reviewed or wants to make a proposal, have some procedure. Perhaps, you know, you have the power in your bylaws to create committees. They don't have to be permanent standing committees, they can be special purpose committees. They can't be composed of more than 2 members of the board or you have an open meeting problem. And again, the bylaws say, in general, it should be a committee of the whole situation, but sometimes work, and particularly when you're talking about policy work, it can be valuable to have people who are not on the board provide their input so that you get a little more wide range of ideas on a subject. So that's something to think about, because I think in this case, as you said, Scott, part of what happened here tonight was a result of the fact that not everybody knew what was going on. There was a policy that had been widely distributed through social media, but was not on the agenda and was not generally made available for everyone to see. And not everybody knew whether or not you're gonna take action on it. So I think that's, from an open meeting standpoint, be mindful of that. Shouldn't be afraid to bring up subjects to talk about. You can express your opinions, you can draft a policy, but you have to be careful about how that gets disseminated. And I think if you were to create a procedure for how things get on the agenda and a deadline that says, hey, if you want it on the agenda for the meeting on the 2nd Thursday of the month, it needs to be submitted no later than 7 days before that meeting. That way there's no ambushing, there's no confusion. You can create your agenda, you can post your agenda, and the subject matter can be posted there so the public can see it ahead of time and decide whether or not they want to come spend their evening voicing their opinion about it, or are they just wasting their time because nothing's going to be done about this tonight. Not to say that tonight was a waste of time.
Mr. Lovacher, may I interject?
Sure.
And I would say it's my heartfelt belief that nobody has wasted their time this evening.
Oh, no.
I think this is an immensely important and immensely controversial issue. And as you say, there's never been a meeting like this at the community library. And regardless of what we decide, it is immensely gratifying to me that this is so important to so many people. And that when word got out that we were going to have this discussion, that so many people with such a wide variety of views showed up and weren't afraid to stand up for what they believe.
I didn't mean to imply that anyone wasted their time. I will say, and I'm not going to get into the weeds about the proposed policy, other than to say that policy as currently written is an invitation to a losing lawsuit that will be instituted almost immediately. I'm not saying that's disrespectful to the people who support it or the person who drafted it. I'm just saying it's a reality, because it's settled law. It's not a case you hear about a lot, but this PICO case is 40 years old. And unlike a certain other 40-year-old opinion that we hear about all the time, nobody knows hardly anyone knows what PICO is unless they're in the library business. But it essentially it says that, in this case, it involved a school district. And a school district is actually given more deference than a public library. But it said that, in this case, petitioners were the school district. And it says petitioners possess significant discretion to determine the content of their school libraries. But that discretion may not be exercised in a narrowly partisan or political manner. Whether petitioners' removal of books from the libraries denied respondents their First Amendment rights depends upon the motivation behind the petitioner's actions. Local school boards, and we can insert local library board, may not remove books from school libraries simply because they dislike the ideas contained in those books and seek by their removal to, quote, prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, close quote. The same argument can be made in terms of a selection procedure. If it is overtly content-driven, and that content-driven is based on differences in religious beliefs, lifestyle beliefs, nationalism beliefs, religion, it's a potential problem. And, so I would say, when you look at these types of policies, you have to be mindful of that. Doesn't mean you can't have some control, doesn't mean you can't say we'd rather not acquire that book. And again, I guess this dovetails into the challenge process. If there is a book displayed in the children's area of the library that somebody believes is inappropriate, they have the right to come challenge that. I'm told the only challenge that's happened in the last 8 to 10 years involved one of the books right up there that has the word sex right on the front of it. I'm not sure if it was in the children's area, but somehow somebody challenged it, and it may have been moved to a different part of the library. That's what I was told. Now, maybe whoever told me that was not quite understanding of that.
My understanding of that, because I was not here at the time, it has always been in the adult nonfiction section. An adult went through the adult nonfiction section, found said book about this educational sex geared for teens, which I have looked through it, and it discusses not really the acts of sex, but sexual reproduction, anatomically correct body parts. That's really all that it defines. It still remains to this day in the adult nonfiction because it does have anatomically correct graphics in it. So no, it's still in the adult.
So it's never in the, but again, if
No.
somebody saw something in the children's area that they felt was not appropriate to be in the children's area, they can do it, they can start the challenge process. And I think that process is there for a reason. And so just be mindful if you're getting into content-based scrutiny, you have a procedure in place already. It's not heavily used. And the outrage that I hear in this room from one side of the perspective makes it sound like the children's area of our library is just a disaster. However, there haven't been any challenges. So, I'm not be very careful when you start to get into content-based review, because you're just opening yourselves up potentially in the city to litigation exposure. And at the end of the day, I'm a risk manager for the city.
And you have to deal with it.
Maybe not.
Yeah.
What would happen is that the city's insurance company's attorneys would deal with it, and then the city's insurance premiums would go up, eventually. So, again, I'm not trying to be disrespectful, but it is a fact that this is out there, and so I think there's some lessons to be learned about how you put how your agenda gets presented and organized, and timeliness of it. I'm not saying you shouldn't discuss addressing this policy, but when you start looking at acquisition policies or weeding policies, be mindful that the law is pretty settled in the area, and contrary to what somebody said here, that the First Amendment only applies to things that Congress do. Well, they apparently haven't read too many cases, because pretty early on, it was not long after that, the Supreme Court said Congress is defined as federal government, state government, and local government.
Yep.
Any government entity. This is a public government board that is fully subject to First Amendment scrutiny. And you guys know that. So I've talked enough. Thanks.
Thank you.